Welcome back to SCOTUS Oral Arguments and Opinions. I'm your host, and today we're looking ahead to what promises to be a fascinating start to the Supreme Court's 2025 to 2026 term. The justices will return from their summer recess ready to tackle some truly significant cases that could reshape areas of law from voting rights to criminal procedure to free speech.
The court has already scheduled its first wave of oral arguments, spanning from October 6th through November 12th. These early arguments include about 19 cases that cover an impressive range of legal questions. The justices have set 10 arguments over 5 days in October and 9 arguments over 5 days in November. But this represents just the beginning. The court typically hears around 60 cases each term, so we can expect additional argument dates and more cases to be added to the docket in the coming months. And, sorry to bury the lead, but as we mentioned in last week's episode, the court plans to hear the Trump tariff cases in early November.
This term stands out for several reasons. First, we have a re-argument case, Louisiana versus Callais, which the court originally heard in March, but chose to re-argue with new briefing on potentially explosive constitutional questions about the Voting Rights Act. Second, the court will tackle some highly contentious social issues, including Colorado's ban on conversion therapy. Third, we see the court continuing to refine important areas of criminal law, particularly around double jeopardy, intellectual disability assessments in death penalty cases, and federal sentencing.
The court's approach to scheduling also tells us something important. By front-loading these significant cases in October and November, the justices appear eager to address some of the term's most consequential questions early, potentially setting the tone for the entire term.
Monday, October 6th. Setting the stage. The term opens with 2 cases that showcase the court's interest in procedural fairness and constitutional rights.
In Villarreal versus Texas, the justices will examine whether courts can restrict communication between defendants and their attorneys during trial recesses. David Villarreal was convicted of murder, but he argues that the trial court violated his Sixth Amendment right to counsel by prohibiting him and his lawyer from discussing his testimony during an overnight recess. The case raises fundamental questions about the scope of the attorney-client relationship during critical moments in criminal trials.
Burke versus Choi presents a classic federalism question about whether state procedural requirements, specifically laws requiring expert affidavits to accompany certain complaints, can apply in federal court proceedings. This might seem technical, but it touches on the broader tension between state and federal authority in our judicial system.
Tuesday, October 7th, First Amendment and Criminal Justice. October 7th brings us Chiles versus Salazar, the conversion therapy case that has drawn significant attention. Callais Chiles, a practicing Christian counselor, challenges Colorado's ban on conversion therapy for minors, arguing it violates her First Amendment rights to free speech and religious exercise. The state counters that this regulates professional conduct, not protected speech. The case forces the court to balance religious liberty, professional regulation, and LGBTQ+ rights, a collision of some of the most contentious issues in contemporary law.
Also that day, Barrett versus United States asks whether the Double Jeopardy Clause prevents separate federal and state sentences for related violent crimes. Dwayne Barrett receives separate sentences for using a firearm during a violent crime and for the underlying robbery itself. The case could clarify when multiple punishments for related conduct violate constitutional protections against double jeopardy. Wednesday, October 8th, Federal Authority and Election Law. Bost versus Illinois. Board of Elections brings us Representative Mike Bost and other Republican plaintiffs challenging Illinois election procedures, specifically state regulations about counting mail-in ballots. The case tests whether these plaintiffs have standing to challenge state election laws and could influence how federal courts handle election disputes.
U.S. Postal Service versus Conan examines the scope of federal tort immunity. When a postal worker intentionally fails to deliver mail to designated addresses, can victims sue the government? The case turns on interpreting the Federal Tort Claims Act's exceptions for mail loss or miscarriage. Monday, October 14th. Criminal Procedure. Deep Dive. 2 criminal law cases dominate this day. Bowe versus United States deals with complex procedural questions about federal post-conviction relief. Essentially, when and how federal prisoners can challenge their sentences after their appeals are exhausted.
Ellingberg versus United States tackles the ex post facto clause, asking whether restitution orders imposed as part of criminal sentences constitute punishment that triggers constitutional protections against retroactive laws. Tuesday, October 15th, Callais re-argument. This might be the most consequential day of the early term. Louisiana versus Calais returns to the court for reargument, and the stakes couldn't be higher. The case began as a challenge to Louisiana's congressional redistricting map, which included a second majority black district following a federal court's finding that the previous map violated Section 2 of the Voting Rights Act.
Here's where it gets explosive. The court has specifically asked the parties to brief whether creating this second majority black district violates the Equal Protection Clause. This question could fundamentally challenge Section 2 of the Voting Rights Act itself. If the court concludes that race-conscious remedies required by the VRA violate constitutional equal protection principles, it could dramatically limit the federal government's ability to combat voting discrimination. The consolidated case Robinson versus Callais involves the same underlying dispute. Together, these cases represent perhaps the most significant voting rights case in years.
Also on October 15th, Case versus Montana examines the emergency aid exception to the Fourth Amendment's warrant requirement. When can police enter homes without warrants based on emergency circumstances? The case could refine the balance between public safety and constitutional privacy protections.
November. Arguments, deepening the analysis. Monday, November 3rd. Liability and criminal justice. RICO versus United States explores the fugitive tolling doctrine in supervised release contexts. When defendants violate supervised release and flee, how does this affect statute of limitations calculations? It's technical, but important for federal criminal practice.
Hensley versus Fluor Corporation presents a unique question about government contractor liability. Can service members injured by suicide bombers sue the private contractors who employed the attackers? The case tests the boundaries of sovereign immunity and government contractor protections. Tuesday, November 4th, Life and Death Questions. Ham versus Smith addresses one of the most profound questions in death penalty jurisprudence. How should courts evaluate intellectual disability claims when defendants have multiple, conflicting IQ test scores? The case could establish new standards for capital punishment's most vulnerable defendants.
The Hain Celestial Group versus Palmquist tackles federal court jurisdiction and diversity requirements. Technical, but crucial for understanding when federal courts can hear cases involving parties from different states. Wednesday, November 5th. Civil procedure. Coney Island. Auto Parts versus Burton asks whether Federal Rule of Civil Procedure 60C1 imposes time limits for setting aside default judgments when courts lack personal jurisdiction. Another technical case with broad implications for civil litigation.
Monday, November 10th. Government liability and religious rights. Landor versus Louisiana. Department of Corrections examines when prisoners can sue individual government officials, rather than government entities, for violations of the Religious Land Use and Institutionalized Persons Act, RLUIPA. The case could significantly impact prisoners' religious rights litigation.
The GEO Group versus Minicol explores whether government contractors can claim sovereign immunity and whether such claims fall under the collateral order doctrine, allowing immediate appeals. Tuesday, November 12th. Federal sentencing reform. The term's November session concludes with two related cases about federal sentencing. Fernandez versus United States and the consolidated Rutherford versus United States and Carter versus United States both examine the extraordinary and compelling reasons standard for sentence reductions under federal law. These cases test whether courts can consider certain legal changes, even those that don't apply retroactively, as grounds for reducing previously imposed sentences. With federal prison populations and sentencing reform remaining contentious issues, these decisions could affect thousands of federal inmates.
Looking ahead, what's still coming? Remember, these 19 cases represent only the first wave. The court typically adds cases throughout the fall, and we can expect announcement of additional argument dates soon.
Based on historical patterns, the court will likely add at least 24 more cases to its docket before the term concludes in late June or early July 2026. The cases already granted but not yet scheduled include several that could prove equally significant. The court continues to receive hundreds of cert petitions each month, and the justices will meet regularly to decide which additional cases merit their attention.
These cases matter because they will shape legal practice and constitutional interpretation for years to come. For practitioners, decisions in cases like Burke versus Choi could change how you handle federal court filings. Louisiana versus Callais could revolutionize voting rights litigation. The criminal procedure cases could affect defense strategies and prosecutorial tactics across the federal system. For citizens, These cases touch fundamental questions about democracy, equality, religious liberty, and the balance between government authority and individual rights. The voting rights cases could determine how districts are drawn nationwide. The conversion therapy case could influence professional regulation and religious liberty conflicts. The criminal justice cases could affect how our justice system treats defendants and victims.
The 2025 to 2026 Supreme Court term opens with cases that promise to generate headlines, influence elections, and reshape constitutional law. From voting rights to religious liberty, from criminal justice to federal procedure, the justices will tackle questions that go to the heart of American law and governance.
In the coming episodes, I'll be diving deep into each of these cases, examining the merits briefs that frame the legal arguments, and previewing what we might expect during oral arguments. Some episodes will focus on single cases that demand extended analysis, while others will group related cases to show broader legal trends.
Once oral arguments begin on October 6th, we'll shift into our regular pattern of oral arguments, argument analysis, opinion previews, and detailed breakdowns of the court's decisions. But for now, this overview gives you the roadmap for what promises to be one of the most significant Supreme Court terms in recent memory.
Stay tuned for more episodes. Thanks for listening to SCOTUS Oral Arguments and Opinions. Talk to you soon.